avant de faire une communication, soit au niveau national, parce que d'après l'information ou l'exposé, il faut d'abord épuiser toutes les mécanismes nationaux afin de passer à l'étape supérieure, c'est-à-dire qu'au niveau des cours, des institutions de l'Union africaine. Mais cette course-là, ça nécessite beaucoup de temps. Et aussi arriver au niveau de l'UIA aussi, c'est aussi un temps considérable. Moi, mon observation est de voir, est-ce que c'est possible? Parce que c'est déjà des questions cruciaux. C'est possible de voir dans quel contexte améliorer un peu ce mécanisme, c'est-à-dire trouver des alternatives un peu à moyen terme pour pallier à cette problématique, parce que l'impatience aussi court. Si nous avons par exemple des communications dans le cadre, je parle dans mon domaine, de la protection de l'enfance, à force de chercher à trouver des solutions, à avoir une solution au niveau national et l'interminable, ça fragilise aussi cette démarche. Il faut que la Cour réfléchisse dans ce sens, comment soit élaborer un protocole comme alternative, de voir dans quel contexte, si on peut avoir un bloqué au niveau national, de ne pas terminer la course au niveau national, mais de passer par une autre protocole pour soumettre ça au niveau de l'Union africaine. Parce que ça marche. Abandonné. Puis, de ma préoccupation. Merci.
Sorry, I replaced Eliane. She's passed her COVID test. So, who was, yes?
Unduly prolonged. What does that, is 5 years will be considered unduly prolonged?
Yes, Dayo, thank you very much. The courts, like the ECOWAS court, seem to be much more attractive now to us as civil society because of the provision of not exhausting domestic provisions or domestic measures, and because also we have problems with the domestic courts because of the way they are influenced by the executive, so we don't trust them very much, but they will go there. But the point is, one of the things that, however, seem to be a bit problematic, which I don't know whether it has other options to it, is the accessibility in terms of cost, because the court is based in Abuja, and victims may have to go there if sessions are being convened, and that could be very expensive for the victims as well as civil society who may not have planned for that, and then there are no revenues or avenues available to generate resources to support court actions. So are there any options within the court mandate to handle some of these issues, to make sure that the accessibility is actually possible and affordable by communities that are vulnerable and poor?
Yes, Gay, you had a question or a comment?
Is it working? Yeah. I just want to put that on the spot a bit more. Yes. I know. Is it better? Your mic is Thank you. It is okay. Is it okay? Thank you. Is it working? Can you hear me? No, I was saying how do you say that in French? That I wanted to put that on the spot a little bit. I'm off again? Am I off again? Technician? Okay. Okay, that's fine. No, thank you. I said I was going to put Dio on the spot a bit. I know we are pressed for time, but we identified a few issues. You know, how unfair trade practices can affect women, children, and of course, even, multilaterals. You heard Manjang talking about the way the Chinese, are behaving in the Gambia. So what I want Dio to do, because he's worked on cases before the Commission, before the committee, before ECOWAS, just to give examples so that those here would get a sense of how these mechanisms work in the real sense. We had a case involving XYZ. We had it submitted to the committee, we had it submitted to the ECOWAS court, and this was the outcome. I think that really would help because not everybody here is a lawyer, right? Yeah, just to make sure at least they can start putting faces to some of the issues he talked about earlier. Thank you. Yeah.
Yes, Brian.
Yes, thank you. So mine is around when you're talking about exhaustion of local remedies. And I think specifically when you talked about the issue of availability or effectiveness, I know, and even from some of the comments that we've had, certain times we generally have misgivings on how efficient our court systems are. And there's been instances also where spirited people, it could be that the opposition members in a political setting, that even when they take these matters or plan on taking them to the local courts, generally they still also have those misgivings. So my question is around what the test is really in order to avoid, speculative kind of taking of these matters to the court, in speculation that I don't think I'll get it because. So what is the test on that? Thank you.
Yeah, should we take one last one? Another round, eh? All right.
Morning. I'm coming from the perspective of an Indian who doesn't know anything about the law. I'll find out what is. I'm taking you now by an individual to access. We know that court cases can take forever, but in this case, how long will it? I would like you to clearly explain the difference between and by. Thank you.
Thank you, everyone. I think, Dayo, you could kindly respond to those, and then we can have a round of questions.
All right. Thank you so much. This mic is working. Okay. First, from CAR, is it possible to speed up national process I think that was what I got. So is there a way that we can speed up our national processes to be able to quickly finish and go to the court or to the commission? I don't know. I think that depends on the individual justice systems of the countries. But the good thing is that the charter, creates an exception to the rule where the procedure is taking too long in your national system. Then you approach the commission. Okay. In some of the cases we've seen, for instance, where a panel had not been set up to hear a case in 2 years, the commission held that was unduly prolonged. And joining this, I think, to Mr. Manjang's question, in some cases, the case had been pending and had not been attended to for 3 years, and the commission held that was unduly prolonged. But I cannot specifically say, for instance, that 5 years mean it's unduly prolonged, because it depends on the circumstances of that particular case. But I think in most cases, if a case has stayed in just one court for 5 years, I think, in my opinion, that it will be unduly prolonged. But you know that exhausting local remedies means going all the way. For instance, in the case of the Gambia, it will be going all the way from the High Court to the Supreme Court. In some countries, that won't take 5 years, right? On the average. So it will depend on, the individual circumstances. But we would be able to argue, I think, if a case has been at the High Court for 5 years, that this has been unduly prolonged. Yeah. Now to Mr. Bremer's question, the ECOWAS has become more attractive to a lot of us in West Africa because we don't have to exhaust local remedies. Yes, I agree with you. The ECOWAS court is so busy now, from a court that used to have about 15 cases a year to a court that is now having about 65 cases in a year. It's become busy, especially from Nigerians. To your question about how access can be improved because of transport costs, I think the court is currently working on that. And COVID has provided a catalyst. Because since COVID happened, the court has largely closed its doors to litigants from coming. What I mean is, I can't go to Abuja to argue cases now. For instance, I was before the courts last week, and I sat in the comfort of my office in Banjul and appeared before the court. So now, in fact, before now, you had to physically go and file your case in Abuja. Now, the court allows to send an email with our pleadings, and that's good enough. The court serves you by email. You may not go to Abuja from the beginning of the case to the very end of the case. So that I hope that they continue to keep that up, but then that also has its own complexities. And I've had a funny experience. I was trying to argue one of our cases before the court, and my internet went off. And the court said, and the point I was arguing was a quite complex issue that I thought they may not understand just from the written procedure, but I never got another chance. So personally, I have been saying let's go back to Abuja, where there won't be any internet problems. I live in the Gambia. Internet is not always great, but access can be improved. For instance, the court can even have a system in which if you want to appear online, appear online. If you want to come to the court, feel free to come to the court. They can have that kind of hybrid system. But at the moment, all hearings are online, so no cost at all. Sorry? To other countries. Yes, they can. The court sits, I think the court has sat in Sierra Leone before. They've sat in Côte d'Ivoire. Recently, in March of this year, the court was in Ghana for about 3 weeks. So they sometimes move around. Although in one of the cases we have handled, which you must be familiar with, the Ebola case against Sierra Leone, we argued for the court to move the hearing of that case to Freetown. And at that time, the court told us we don't have the costs. We don't have the money to be able to move this to Freetown. And you also have to know that the court is underfunded. You recall that before 2018, the ECOWAS court used to have 7 judges. Now they have 5. And that has its own problems in terms of language, in terms of... So, for instance, last week, we got a decision also against Sierra Leone. All pleadings were submitted in English. All arguments were made in English. Judgment was rendered in Portuguese. Because they don't have enough judges, you see. So, anyway. I want to come to Gay's question last because that will take some time. To Brian's question about can we take matters to the commission because we think we're going to lose at the national level because of the problems we have with our judicial systems. We think, the judges are corrupt. They would always side with the government. Or, I'm an opposition leader, the court will rule against me. Unfortunately for us, in that respect, the commission has always ruled that you must at least attempt to exhaust local remedies. So it's not enough for you to say, I think I will get a bad judgment because of who I am. You must at least attempt. But there's also been cases where the commission has looked at the justice system of that country and has heard that the justice system has broken down completely. In the case of Eritrea, and that because the justice system has broken down completely, one cannot be expected to get justice before the justice system in Eritrea, and the commission allowed communications to proceed. But in most cases, you have to have at least attempted, except where you know the court has ruled on these issues before, and it is clear that they will rule in the same way over and over again. For instance, in the Gambia, there's the case that went to the Supreme Court a couple of, I think 2 or 3 years ago, about provisions of the Public Order Act of the Gambia. And the case had been made to the Supreme Court of the Gambia that the Public Order Act was too restrictive on human rights. And the Supreme Court of the Gambia held that, no, this Public Order Act is fine as it is. It doesn't unduly restrict human rights. So if tomorrow I have a problem with the Public Order Act and I go to the High Court, I know what the decision would be. In that kind of case, then I could approach the African Commission or Court directly because I already know what the decision will be at the High Court. I won't win. There's no chance of success. And that's what we talk about effectiveness. Imo's question talks about the process of accessing the ECOWAS Court by individuals. Like I said before COVID happened, we would have to print all our documents, put it in a box, put it on a plane, and fly to Abuja from Banjul. But now it's enough to just send an email with all the processes. Things have really become easier because I've had a number of funny experiences with appearing before the court. So in those days, there was no direct flights from, and until now, there's no direct flight from Banjul to Abuja. But before now, it used to take about 3 days to travel to Abuja because you had to fly to Dakar, then the next day continue to Abidjan, and then to Abuja. And at least 3 times, I was in Abidjan and I got a call from the office. We have just received a letter adjourning your case. But I was almost in Abuja. So in those times, it was quite problematic. And I don't know whether to say we are glad that COVID has provided the catalyst for some change. Your second question was about what is the difference between judgments and recommendations. The African Commission and the African Committee of Experts on the Rights and Welfare of the Child are referred to as quasi-judicial institutions. They are not courts per se, even though they can take communications, they can consider complaints. And so at the end of the process, at those kind of institutions, what you have is them recommending to the state as to how to remedy the violation. In terms of technical legal application. It is not binding per se on the states, even though I argue that it is binding because it is an interpretation of the African Charter, which is binding on the states. So, excuse me. But then for the African Court and the courts, the East African Court of Justice, the ECOWAS Community Court of Justice, the decisions of those courts are binding in themselves as decisions of the court. So it's binding in the same. Okay, I wanted to say in the same way a local court is binding, but there's still some differences in that, because the way you enforce a local court judgment is not the same way you enforce an ECOWAS court or an African court's judgment. So that's the difference between judgments and recommendations. Now, to address Gay's question, I don't know how much time we have and how much I can say. But IHRDA has litigated before all the mechanisms I've mentioned, I think with the exception of the East African Court of Justice. And that's because the East African Court of Justice, like I said, does not have a direct human rights mandate. So we've litigated before the Commission, the African Court, the ECOWAS Court, the African Committee of Experts on the Rights and Welfare of the Child. So I'll look through the room and I'll try to pick cases from places where we have people in the room. My eyes first see Sierra Leone, and which case we have about 3 or so cases that we've done against Sierra Leone. The most popular one being the Ebola one. But okay, perhaps I should talk about the case about the exclusion of pregnant girls from mainstream schools. I think this was during the Ebola crisis in 2014. The Sierra Leonean education minister had made some kind of statement asking schools not to accept girls who are pregnant back into school because they will be a bad influence to other girls. So with some of our partners, particularly an organization called Equality Now, we brought a case before the ECOWAS court alleging that ban on pregnant girls going to school was discriminatory and a denial of the right to education. And after some long process, yes, the court agreed with us and overruled the ban. Now I recall there was a question on how long does it take to finish a case at the ECOWAS court. On the average, it takes about 2 to 3 years on the average. But I have found out recently that we lawyers can speed that up. And so there's a case we filed in September 2021, and we got judgment in July 2022, which is about 10 months. Yeah, less than a year. That's, how much time are you giving me? 5 minutes. Okay. At the Committee of Experts on the Rights and Welfare of the Child, I think it also takes about 3 years, 2 to 3 years. At the African Court, I used to think that it took 2 or 3 years, but now I think that is changing because we have a case we filed as far back as 2018, which till now has not even been heard. And we have cases that we filed in 2020 as well, which have not been heard. At the African Commission, however, that is a bit long. And I know my boss Gay makes the joke about how you go and argue before the commission that local processes have been unduly prolonged because it has taken 3 or 4 years. And now the case comes to the commission and the commission takes 7 or 8 years to conclude your case. So it's a bit, the commission has certain problems that make the length of time to consider communications very long. But perhaps we shouldn't go into those today. We've also litigated at the committee. So we recently, in 2019, I think, got a decision against Cameroon at the committee in respect of a young girl who had been raped by some influential person in our community and who, when the case went to the courts, the courts ruled against her at the court of first instance, and the magistrate seized all the records and did not allow an appeal. So effectively, she didn't get justice. So the matter was taken before the committee, alleging violation of a right to a remedy, a right to freedom from inhuman and degrading treatment, a right to dignity, and so on. And I think the case we filed it in 2015. We got a decision. Actually, the decision was in 2018, not 19. We got a decision in 2019 agreeing with us that the girls' rights have been violated and issuing several recommendations to the Republic of Cameroon as to how to remedy the violations. Unfortunately, most of those recommendations have not been complied with till now. So last year, the committee invited us to an implementation hearing to come and tell the committee what, for the state to come and tell the committee what it has done, and for us to be able to also give our views on what the state has done. And as you know, the state always paints a rosy picture. We've done this and that, but it's not always the exact picture on the ground. So we're able to present that. My time is up. Okay. I think I should stop here. But if I start talking about cases that IHRDA has litigated in the last few years, I might need about 3 or 4 hours more. So let me just stop here. Thank you so much for your attention.
Thank you. Thank you, Madam Chair. Just 2 small minutes to tie it in with what we are discussing. So Continental Free Trade Area, what will be the takeaways from this presentation for us with all these mechanisms? And yesterday, as George started giving us a background, he said, do not look at AFCFTA in isolation. This is situated in other developmental frameworks. Agenda 2063. If you look at Agenda 2063, it speaks to economic and social justice, which is rooted on the African human rights system, because references are made to the African Charter. So what is the benefit of knowing these mechanisms and what we want to leave this room with? We are then going to start urging these treaty mechanisms in the course of the cases we present. Of course, we do litigation, but there are other aspects of their work, state party reporting, the investigation mechanisms that they use. And for colleagues who are not familiar, the Commission, the African Committee of Experts, have the mandate to also undertake investigations into issues on the ground. So as we leave this room and go further to even look at these mechanisms, and as we, at the end of today, hope to have a working movement of human rights defenders with a focus on AFCFTA and human rights, let's begin to look at how, in the work towards broadening access to services, for instance, you're thinking of better access to the mechanisms. The UN Human Rights Treaty system now has an online application system, even for communications, very user-friendly for anyone to be able to use it, so that you are not only looking at access in this regard for just lawyers, but ordinary African citizens. Here in Kenya, we are sitting here and we are picking up issues of children being trafficked across the border from Uganda. So you want to get the human rights bodies thinking. As you are looking at opening up borders, you need to put in the brakes and the checks so that they also do not foster abuse. So I just wanted to throw that in for us to make the connections, not just look at these bodies in isolation, but think of how we're also going to marry them with this. That is how we are going to mainstream. Thank you.
Merci beaucoup, Monsieur Edmond. J'aimerais demander à tous les participants d'applaudir Monsieur Odayo pour son exposé si enrichi. Et je remercie aussi tous les intervenants pour les interventions enrichissantes. Et je passe la parole à Madame Lydia et merci pour tous.
Yes. Okay.
Yes.
Yes,
I'm here. Gay, how are you?
Yes.
Thank you so much. Thank you, colleagues. I think we are doing well. And now we want to have some panel discussion. And before we start, maybe let me just try to jog your minds that as from yesterday, we've been talking about AFCTA as an initiative to create a single continental market for goods and services across the continent, supported by free movement of business, persons and investments, while paving the way for continental-wide customs union. The other thing that is of interest to us is that as Africa, we have a population of about 1.3 billion people across 55 countries with a combined GDP of about 3.5 trillion US dollars. And we are in agreement that the agreement can lift about 30 million of our people from extreme poverty if well implemented. Some available data suggests that when implemented, the deal could also boost intra-African trade by about 52.3% by eliminating import tariffs and even more if non-tariff barriers are also reduced. As we heard yesterday, we have some negotiations that are completed, some are ongoing, and there are some countries, a good number, that have ratified this particular initiative, but some are still dragging their feet. And as human rights defenders, that's where we need to be awake and be vigilant in ensuring that this particular process is brought to fruition. Our main objective of this panel discussion, one is to give the participants an opportunity to ask some questions that maybe were pending from yesterday's presentations that we had. And to be able to help us have more insights in some of these issues, we have three able experts that will be able to share with us some perspectives from various angles. With us, we have Professor Mkundi George. Professor George, say hi. And then we have our able sister Salma Namsobia. You know, I'm a Bantu, so sometimes I can pronounce it as Namsobia. Is that okay? Thank you so much. And then also we have my good friend Gay So from Institute of Human Rights Development in Africa. Gay, I'm struggling to see you. You are taller than me and I'm not seeing you. Please. Thank you so much. Yeah. I've been insisting, I've been having some quarrel with the leader that I want panelists to sit up front. But she was saying the place is so squeezed. Thank you so much for listening to me.
Hello.
Sorry, I'm supposed to use this.
Hello. One. It's good. All right.
Okay. Just to remind you, panelists, our discussions are about addressing the human rights concerns and implication in the FCTA negotiation and implementation processes. And I want us to deal with the credibility, the dignity, and integrity of these processes. And as you know, we are human rights defenders. And mostly we are not defending the interests of the elite. We are defending the interests of the lowly in the society, the communities, the vulnerable groups. These are the people that we work with in our various jurisdictions. So to start us off, I want to invite each panelist maybe just to give an opening statement before we delve into more pressing matters. I start with Professor George.
Thank you very much, Chair, and good morning, colleagues.
Hello.
I don't know how we are going to work with these mics now.
It's not working?
No, because it affects.
Oh, it affects the interpretation. Sorry?
Hello. Hello.
They can't get us?
They are not as clear
As this was. Okay. Oh, that's why I think. Now I get you. Okay. So, what do you suggest? No, for interpretation. Interpretation is a must. Now,
Hello.
how about maybe the next? Sorry. Yes. Yeah. Yeah. Please. If we can get space for them.
Just for switching that.
Oh, this one.
Hello. 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 Okay. Okay. All right.
Okay. Can I check if the interpreters can hear us? You can hear us? So I bring it a bit closer. That's better. Thank you. So good morning again, colleagues, and apologies for that a bit technical hitch. So as you've just been told, and I introduced myself yesterday, I thought it's only fair that I do that again for purposes of this process. So my name is George Mukundi. I am a human rights defender as well. And so I'm happy to be amongst colleagues and friends and really appreciated all the feedback and contributions that have been made. I wanted to really begin first by emphasizing the point that was made by Dio. And in fact, also Edmund somehow supplemented it by insisting that although the first session which we've just had on what IHRDA and human rights defenders can do, but you have to see this process, especially through the CFTA, in the sense that we are looking at litigation at the tail end of the challenge. And of course, as lawyers and as IHRDA, which is really well known for strategic litigation, perhaps there is always a tendency to focus on our comfort zone. And the comfort zone is that tail end when then things are not working. And I wanted to suggest three things. One, that we think about the strategies and the conversations and the issues you'll ask us is how do we also make sure the three other components in that we know very well that prevention is better than cure. Now, we presented quite a couple of ideas around how do we influence the current legal processes, protocols being drafted around the CFTA that are not yet finalized in phase 3 of our process. And I think there's a role for IHRDA, there's a role for human rights defenders. The second point really is also the whole idea about sensitization, creating a buzz and making sure that we are not only aware, but also our citizens, who are the persons who we try to influence, understand and appreciate what it means really to be able to be part and parcel of benefiting from the CFTA process. Finally, is what we then had suggested, tracking implementation. As civil society, as human rights defenders, how we track that. And I think there could be an actionable and a dashboard or a tracking tool, a scorecard perhaps, that would help us to be able to see, are our countries doing enough? Should they do more? and what more could we equally do other than asking only what government can do? Thank you.
So much, Salima.
Okay, good morning once again. Just to follow up on what George has been saying, I first of all want to re-emphasize again what we've said, that there is potential for the process of the Africa Free Trade Continental Area to enhance enjoyment of rights for vulnerable groups. But what does that mean for human rights defenders? First of all, nobody is going to give whatever we need on a silver platter. We will have to find the spaces for us to engage by ourselves, and we shall have to ensure that we are engaging states, engaging the private sector, engaging communities, and engaging financiers, because they will also be important players in this process. But nobody's going to invite us to the table. We have to do it by ourselves. Then the other thing I want to emphasize is the issue of partnership, because this is going to be a regional process. So it will have to move beyond borders. And not one institution, not one organization is going to be able to do all the work in order to create impact. So we have to partner. You know, we have institutions like IHRDA that have tried to work at the continental level, but they also work through partners, if I'm not wrong, Gay. So we have to know, you have to identify institutions that you can work with, you know, from the different countries, and be able to monitor and see what is happening in particular countries, how are they implementing the various aspects of the various either protocols and the commitments that have been made under the agreement. Otherwise, there will be very, very limited impact. And then also trying to get the people that we care about getting involved in the processes. You know, African systems, yes, we do have political leaders. Some of them are beyond the level of shame, but for many of them, once communities speak, they are bound to respond faster than when you have only civil society organizations speaking. So for those that can listen to communities, they know what is at stake, that if I do not do this way, then probably I may not be voted back into power. And we have to put communities at the forefront as we are engaging in this advocacy process to ensure that we create impact.
Thank you so much, Salima, for the opening statement. My friend Gay, please.
Thank you. Can you hear me? I was thinking the mic does not like us. Yeah, I mean, we all are human rights defenders, and it's our responsibility to hold our governments accountable. We know all these processes are being negotiated. So what is expected from us as civil society? We need to push, we need to ensure whatever consultations we have going on at the national level are broad-based. You remember we're talking about phases. Phase 1 completed, phase 2 in the process of being completed. So at the end of the day, it really wouldn't be about our government signing, parliament ratifying. Consultations are needed at the national level. And it's our responsibility to make sure those consultations are as broad-based. I mean, people we tend to forget are included. Like normally when these negotiations happen, you would just have probably men above the age of 40 negotiating, telling us what to do. What about our children, participation? What about the youth? What about the women? Oh, okay, sorry. No, is it better now? Okay. No, what I was saying, we heard from the speakers that phase 1 is negotiated, phase 2 is in the process of being finalized. And because it is our responsibility to hold our governments accountable, we have to make sure whatever process we get involved in, you know, consultations at the national level are as broad-based as possible. Because in most cases, when these discussions happen, you normally would have older men in a room, talking about what they feel is best for us. So there are people who always are marginalized, like the women, the children, the youth. So we have to make sure at least we get them involved in the negotiation process, broad-based. But then it really wouldn't also be just about ticking the boxes. We need to also make sure the participation is meaningful. It makes sense. I think that really is key. One other thing, because we know litigation, of course, is towards the tail end. There were some issues that are listed, and I think as civil society organizations, we really have to make sure we make very good use of them. Like, he talked about commission sessions. I mean, some of us here have been to many of those sessions, not just the commission, even the committee. If that is an issue of concern to you, nothing stops you from taking the floor, particularly if you have observer status, to bring that to the attention of either the committee or the commission, at least that way. Because unfortunately, for a lot of us, our governments tend to take us more serious if the pressure is coming from outside, like somebody in Banjul sending a letter and all that. I think that is a process we should make use of. He also talked about special mechanisms. I think that too is something we can make use of, like issue of concern, probably, a Chinese business getting involved in very unfair trade practices, degrading the environment and stuff like that. The lady sitting next to me is a member of the African Commission Working Group on Economic, Social and Cultural Rights. So sometimes about sending an urgent appeal, bringing that to the attention of the Continental body concerned. So all these are things we really have to have at the back of our minds. I'm saying in senses, we need to be as open-minded as we can be. So let's not just concentrate our efforts at the local level. Let's try to make use of these. I'm not making use of them. It's always about filing cases. There are other ways you can engage them very, very meaningfully. We need to make sure at least we have all at the back of our minds. Thank you.
Thank you so much, panelists, for your opening statements. Now, maybe just to be able to be about what we've been discussing since yesterday. First, maybe Salima to share with us the best practices, if any, that human rights defenders can use protection of human rights within the NFSTA discussion. Thank you. Salima.
Okay. First of all, you give as good as what you have yourself. We first of all have to ensure that we do understand what this framework is all about. It is a complex issue, but everybody around the table has the capacity to do the reading. As human rights defenders, we need to understand the process before we start engaging. And like I said yesterday, because we are also involving the private sector, and there will be advocacy against both states and private sector, sometimes you can get away with it if you're talking about things that are not very accurate about states. With the private sector, you will not get away with it. They are going to sue you for, giving them a bad image about things that are wrong. So evidence gathering, ensuring that what you're talking about is factual, is going to be a key first step. So whoever is getting money from funders and whatever to work around this process, ask them to first give you money for research, for evidence gathering before you start engaging in advocacy. Otherwise, you get quickly dismissed and discredited also. If somebody just picks up on a wrong thing that you've said, the minute you stand up and somebody says, that is not accurate, people will not listen to the rest of the things that you say.
Salma, if I may cut you short. So what you are saying is that our struggles, our campaigns should be evidence-based. Proceed, please.
Absolutely. But also, like I said, the best practices, especially now that we are working on the continental level, what I said earlier, partnership. Because like Gay was also saying, we need to deploy multifaceted approaches. We know that, yes, there is all these mechanisms, but not everybody is going to be able to utilize them. I may have the facts, but Dayo will have the capacity to engage with the various quasi-judicial and judicial mechanisms. So if you partner and you give him the information, this is what is happening, there is a violation here, and they are able to bring the case, then that is more efficient and it's more effective because everybody has various different expertise. But also we will have to work across sectors, because again, this is not a single issue process. So there are those of us who are working on debt, there are those of us who are working on health, there are those of us who are working on corruption. We need to have partnerships that are cutting across such that we all aid each other. Otherwise, if we decide to remain in our silos, then we shall not be having a lot of impact. Of course, continuous monitoring. We have to be on the ground at all times. We have to keep the pressure up. If we decide, for example, that there's a policy engagement that needs to be done, maybe at the AU level or something like that, we have to consistently keep the pressure up. We have to do the PR. We have to be out there all the time, not have a single meeting today and then the next time we are engaging, we are doing it next year or 2 years afterwards. That will not be helpful.
Dr. George, can you be able to cite best practices in this regard?
Thank you very much, and I wanted to equally also just build a bit on what we had said yesterday, but what Salima equally has said. The biggest difficulty, and the question you recall I had asked colleagues, is how much time we'd invested in even understanding themselves. The truth is, and I think that's what I think, is we always assume that the other side is not willing to listen. We always assume the other side is hostile. But hostility is also a perception. And sometimes perception is not the reality. And that's the real truth. When we all walked in here since yesterday, you had different ideas about who walked in. And depending on how you engage with them over lunch or over drink or even in conversation, perhaps your mind may have changed. And that's one main point in terms of civics strategy or human rights defender strategy, to not always assume things are bad. And I hear many of us, of course, really resigning and saying, no, things are not good. Yes, but can we also look at what actually can happen and does happen? And that's the emphasis, that the first space is really not to want to reinvent the wheel, which is what also civics and human rights defenders, including institutions, because you get money from donors and funders, organizing parallel platforms, imagining that those platforms actually then can influence. They will not, because they have no legitimacy, they have no credibility. The question you had asked earlier. The credibility, legitimacy, unfortunately, is something that is cultivated over time. There's always one of the key arguments usually said that there is no political will. Is political will something static, or can you cultivate political will? And that's a very useful area to think about. That you can actually work with somebody to actually impress upon them on why they need to change their mind about how they look at us. And that's really, I think, extremely important in the issue of trade, which is not traditionally human rights, but we have to embrace and make sure that we convince our other colleagues to see that human rights is a key core component and highly interfaced with trade, if this has to be sustainable, but also it has to make sense. And that's why, the question that was asked about ECOSOC, the African Governance Architecture Platform, the Pan-African Parliament, and all those mechanisms, that one that has just been highlighted by the Executive Director, IHRDA, Geso, to say that there's the African Commission, there's a committee, there's also the AU Commission. How much of those processes are we engaging before we run just to take cases to those processes, so that we're able to influence? For me, that's a very good best practice. And IHRDA is one of those ones. The session that they'll have tomorrow and the day after, I think, engaging Kenyan government on one of the cases on Nubians, I think is mind-blowing to think of it, because I do not think that's traditionally how they had envisioned they would want to engage government. Because they thought, we go to court, we litigate, we get a decision, the country does it. Now they're having to go back to the drawing board and saying, I think we also need to engage this government to explain to them, to understand their fears, to understand their concerns, so that when you're saying you're not implementing, perhaps some of the decisions have been implemented. But all authors, critics, we usually say, government is doing nothing about it. They're not implementing. How do we know? We only know if we are talking to the right people. So I wanted to give IHRDA as a case example on something I know they'll be starting tomorrow, engaging the Kenyan government. And I know I'll throw back that work actually to Geso to say, why do they think that they need to actually have a dialogue with the government on an area that is not one of the things that they've done severally? But increasingly, I think that's where the future holds. And on trade, you cannot, because we're not experts.
Thank you so much, Dr. George. I know Gay is itching to make some addition.
Yes, you because remember, we're talking about government, very powerful. And in some instances, we're also talking about very big businesses. So best practice, we definitely would expect you to be very innovative, and not also to stick to just one approach. Whatever is workable, whatever is possible, you at least have to find a very good way of, using it. Salima said something about partnership, networking, collaboration. I think that is extremely important, and I'm going to use IHRDA as an example. You've heard, from yesterday, when I gave my opening remarks, Edmond's interventions, Dio talked about IHRDA litigating before all these mechanisms, tons of cases, going back 1998. That maybe, and of course you also heard from Dr. Mukundi talking about, engagements we intend to have tomorrow with Kenya's government, IHRDA. Impression given, of course, that this is a big organization, probably with about 200 lawyers. That is not the case. What we try to do, we try to partner. In all the cases we've worked on, in all the cases we're working on, we always would have a local partner. Like the pregnant girl's case against Sierra Leone, we had WAVE. The Nubian cases, we had, Semirite. The Cameroon case that I referred to, we had FGI, tons of other cases. What we try to do, usually a very convenient marriage, and I see no reason why we cannot do the same here. We would have the local partner to lead on the local stuff. My expertise is international human rights law, but then I'm not an expert on Sierra Leone. So I would need a local to lead me on anything Sierra Leone, from the context to the laws. That helps. And of course, when it comes to litigating before the commission, I would lead. But then that way we also build the capacity of the local partner, making them realize your options are not just restricted to what is available in your country. There are other, you are like spoiled for choice at the international level. So I think it's important we have that at the back of our minds. So for me, it's really not just about the convenience. It's also about legitimacy. I mean, who is he? He's from Gambia. Why is he coming all the way to Kenya to talk about the Nubians? What is in it for him? That kind of thing. But then the minute they realize it's not something you're doing because you are a troublemaker, you also have the support, collaboration of partners on the ground. That tends to at least make our governments take you a bit more serious. But then going back to the point Dr. raised earlier on, I mean, CSOs, we don't implement. All we do is advocate for implementation. Who implements? The primary duty bearer is the state. So there is the need at some stage, at some point, for you to sit with them I mean, that way you can at least push, you can lobby for them to go ahead, so which means the approach does not always have to be adversarial, fighting statements, knocking each other down. Sometimes there is a need for you to sit with them in a room to find ways, because it's mostly not about you. You're the lawyer, but you're representing people, you're representing victims. So if you make it about victims, I'm sure you really wouldn't have any problems when the need arises for you to, have a conversation with stakeholders, including the state, whenever possible. So again, let's network, let's collaborate, let's partner. It's only that way we can put a change around the continent. Thank you.
Accused as HRDs as more militant in our approaches. How do we ensure that we balance objective engagement, just as we said, Dr. Gay? Maybe if you can try to shed some light on balancing militant approach in our advocacy work and objective engagement before I go to Dr. Mukundi.
Can I start? I'm going to use IHRDA again as an example. When we do training, the training is not usually, it's not always for, sometimes we do training for judges, and in fact, lawyers, government lawyers. And where we're based in the Gambia, when our help is required, we give it. We have just recently we did training for lawyers at the Ministry of Justice. We passed the training for members of the intelligence that we invited to come in. We don't say no because we're on the other side. We try to support whenever we feel our support is needed. Like if we do not give the support needed, there would be a void. But at the same time, we also try to maintain our independence. In the sense, we will support whenever we can, wherever we can. But at the end of the day, if you do wrong, we'll hold you accountable. We've provided all kinds of support to the Gambia government. But that hasn't stopped us from taking the government to court. There are cases we're litigating before the ECOWAS court against the Gambia. There are also cases we're litigating before the African court against the Gambia. So it's about striking that balance. If you need to hold the government accountable, you need to do so. But at the same time, if there is room for you to help, you're not the enemy, you're not the government's enemy. If there is need for you to help, if they can rely on you, they need your expertise, you have to be ready to give that. Because we're talking about rights for all. Government too deserves justice in deserving cases. So we also have to have that at the back of our minds. It cannot always be adversarial. Sometimes there is a need for you to talk to those who, make things move, to make things happen.
What do your voice?
Thank you. It's really supplementary, and I want to put it in two ways. One, and there's nothing wrong, no harm. In fact, it's a term that we embrace of being militant as human rights defenders. There's nothing wrong with being militant. There's nothing wrong also with being diplomatic. There's nothing wrong also with being street smart and streetwise. There's also nothing wrong with being thought leaders. In other words, the human rights defenders movement is not a uniform sector. It has multi-prong, multi-track, multi-strategies that we all adopt at different times. The truth is, as we've learned, there's space and time for all things, and they have parallel movement or flows, but they can also be paced and sequenced, depending on also how we approach these issues. I mean, when you're in court with the other side, they're not necessarily your enemies, but your opponents in terms of arguing those cases. But you'll go out and have coffee with them to discuss other issues that are not necessarily in court. I say that because from what we've learned from North Africa, from what we've learned in Burkina Faso, even in Nigeria, in the streets of Lagos, the decisions aren't made in the streets. It's for that conversation to be able to highlight it so that the decision makers then can actually walk into the boardrooms to make the decisions. So we must never forget, as human rights defenders or even as civics, that shouting hoarse on our voices is not enough. We then have to take it to the next level, to be on the decision table, to discuss what the strategies are. I always say, back in time, in our youthful days, in Southern Africa, we always used to ask SADC to give us a chance to walk into the offices to tell them what needs to happen. Until they decided to do so, we freaked out because we had no idea what we wanted to do. So we knew how to say what we wanted to do outside, but not when we're inside. Then you freeze. And that, unfortunately, happens a lot. And I can tell you from experience, having also worked within the AU system, that happens a lot. The reason why I say this is that, how do you influence? You're either the chair or the rapporteur. That's how you influence policy making. It's unlikely you likely be the chair. But we also know, because even in our own country's capacity issues, willingness to be able to be part and parcel of the rapporteuring groups, if you're invited or not invited, and we know how even these processes happen, I think is key. The point I wanted to make is that we really have to find time for civic tech, for digitization, for all militant approaches, but also supplement them with other actors who choose different and embrace all those as human rights defenders. And those that are deciding to work differently, we will not be the ones then saying, because you're not on the streets with us, you're no longer a human rights defender. I don't think we should have labels. Is what is the end result? What's our why? I think that's what matters.
Salima, you wanted to say something? I don't want to ignore you.
It's the same thing that George and Gay are talking about. It's usually helpful if you have value addition to the people that you're engaging with. AU, right now, my organization and 4 others are working with the African Commission on a general comment on the state obligation to service delivery, and stating now presenting to the commission. But you know, like, people will always engage, and they will know there were times when the commission didn't want to engage with civil society organizations, you know, because of different perceptions of how they presented themselves to the commission, because they have come just to show that we are here to critique, or we are here simply to take away and become popular by engaging with you. So once people realize that you have value, even when you criticize, they will not be very angry with you. And I can also give an example of our process of developing a national action plan on business and human rights in Uganda. Again, it was a civil society driven process, but where there was partnership with the government from the beginning. But we used to be there providing technical assistance, showing them this is what we need to do. This is how to draft it. We offered to be part of the drafting committee until we saw the NAP coming through. So in other cases where we are suing the government, they will say, but you people, you work with us, but other times you're suing us. Why do you sue us when we are working with us? And, you know, we laugh and discuss why we are suing them, and, you know, it will pass like that. But they can't avoid us because they know the value that you bring to the table once you walk into the room.
So much. That one reminds me of one of my primary teachers. He was very strict, and he would cane you well, but by the end of the day, you'll appreciate his caning. Gay, in the FTA negotiation and implementation processes, as with any other initiative or concept, we are bound to encounter challenges and things like that. What are some of the challenges do you envision in these processes, please?
Hello, hear me? Okay. I think many, but I will I talked about this at the beginning, but I'll concentrate on, because we are, you heard from the presentations that phase 1 is already completed, and phase 2 is about to be finalized. But how many of our people, in fact, how many people in this room are aware what all those phases, entail? as in, trade in goods, trade in services, or are we talking about intellectual property? So in a sense, the point I'm trying to make, one of them is whether there was enough consultation, or the consultations were broad-based enough, or they were meaningful enough to such an extent we can say everyone, who is likely to be affected was carried along in all these negotiations. I am not aware of civil society in the Gambia, or even our National Assembly, or probably those who are most likely to be affected by, all this, what is it called? Agreement, ever sitting down to have a proper national dialogue on the issues. So for me, that is a big minus. So if we say free trade area, is it free trade according to our governments, according to politicians, or it should be free trade according to us, particularly those who are most vulnerable? So I think for me that question is not yet answered, and it gets me really worried, Yeah.
Which groups are vulnerable in this process, and why do you think so?
The vulnerable groups with the free trade area arrangement?
Yes.
Yesterday, I mentioned some of the groups. First of all, the groups that are involved in informal trade are most vulnerable, and we know that within that group, there is over-representation of women and youth, and migrant workers. They are very vulnerable because there is a real risk of being crowded out of the process as processes become more formalized. Many of these people do not have any registration. They just wake up and do business. So that process may become difficult and bring in more formal and bigger actors that may occupy the space because they are able to navigate these processes. But also children are particularly vulnerable because, of the cross-border arrangements and the various laws that may be there in the different countries. So while some countries may be strong on, for example, ensuring there is no child labor, other countries may not be that strong, and there could be a lot of trafficking for people. Like how you saw globally that people started, big companies started moving to countries that were more open to, that have less labor standards. For example, China, the migration into Asia, companies coming from the US to go and operate in Asia because they are free to use child labor, they are free to pay below a minimum wage and all that kind of stuff. We could have this happening, and children may be caught up in precarious labor in the process. But also, like I said yesterday, also refugees and other migrant workers. Refugees, again, because of the porousness that is going to be created around the borders. So first of all, the issue of safety is a key one, because then the people you could be trying to run away from might find you as easy as possible with the free movement. And yet here we are saying if free movement doesn't happen, then the trade area is going to fail. So there is two sides of the coin to the issue of free labor, especially in relation to the refugees. So for them to operate in an open border arrangement, it is going to be very difficult, and they may decide to retreat and get out of the workspaces. So there are a number of vulnerable groups. Of course, when you talk about the women, also the children, we could see an increase in harassment around the informal trade arrangement, but also indigenous groups. you know that, for example, in Uganda, we have some groups, I think they are also on the Kenya side, the Turkana, and on our side, the Ngakarimojong. You know, they're used to their own movements around the area. So if people are now going to broaden and bring into that space other players, their own life, their culture, their way of doing trade is going to be greatly impacted. And that is not the only group. You know that one of the priority sectors is also tourism. And with that, many players may want to come and appropriate particular spaces to be able to use them for tourism. And in such cases, some of the indigenous groups, you know that many of them are tourist attractions, and they may be impacted in terms of their cultural well-being, in terms of their life. So, yeah, it depends on what is happening at a particular time, but vulnerable groups are quite many in this process.
Before I open the floor for questions or comments or observations, maybe in 1 minute, Dr. Mukunde, how do we motivate political goodwill to place human rights in the trade reform processes as human rights defenders?
Yeah, so first, thank you, Chair. In a sense, it's almost a summation of the issues that we've been trying to suggest, and it links to some of the challenges that have been highlighted by Gay and Salima, in the sense that we are entering a technical subject, or so it's been made to sound like a technical subject as we presented it yesterday. And half of us, of course, fear getting into year 3 of a 4-year graduation, assuming it's a 4-year graduation. It's only 3 years. So we must not forget that it's very young still. So we are not late. We are not late into the game. 3 years in terms of how far this thing has gone. And it's not a 4-year degree. We have a 50-year, 100-year plan. So there's a lot of upskilling that needs to be done for us to be able to actually influence these policies. Because only then do we then get the credibility and the legitimacy to offer thought leadership of what and how human rights defenders can actually protect the right of citizens, and how the issues of a human rights-based approach to engaging on the CFTA is important. But we are only able to do that if we engage in the private sector, we engage in government, we engage in multilateral stakeholders, including all the IFFs, I mean, all the international financial institutions and others who have a stake in their view on this matter, including the Chinese, including the Eastern folks. Everybody is involved in these processes. I think that, for me, is one of the key areas, upskilling, but importantly also, something I've learned from this room is the usefulness of this partnership that is suggested with other traditional, non-traditional media platforms, Watoto News, West African Radio. All our people, everywhere, anytime you're driving, you listen to radio. How often do we use radio to communicate to our people? But this conference, nobody will know about it other than the first stuff we managed to get on Twitter. I mean, maybe they'll do a press release. But assuming this conversation also was happening in radio, you can be sure there will be a much higher constituency listening to these discussions. And why I really think we have to invest in radio.
Thank you so much. And yesterday night I was talking to one of our member of parliament in Kenya. If he knows about FTA, he says, "What's that?" You can imagine, now we are going to elections. Now I open the floor for any comments, questions. Yes, remind me your name once again. Najin, yes, please.
Thank you so much for all the panelists for their comprehensive presentation. I think this session is the core of this workshop. We've been asking since yesterday what are the strategies that can be implemented to protect human rights, especially in the continental treaties like the African Continental Trade Area. So, in fact, we started getting feedbacks and regarding these strategies. And I have seen that all the panelists have emphasized on advocacy, sensitization, litigation, building capacity, and getting in touch with CSOs. Also, how human rights defenders can and CSO can engage with the regional mechanism. And we have seen a presentation on the three mechanism. That is the African Commission, the African Court, and the Committee of the Experts. So, in addition to getting in touch, making communication, reporting, and also what is important to have. Observer status in relation to African Continental Free Trade Area. I think we should work on two levels. The first level is nationally. We have to see the bilateral trade agreement between two countries. And the regional also, like example of ECOWAS, the regional agreements. Also, what is important in terms of also mainstreaming human rights within the African continental trade is networking. We need networks. I think we should come up here and create a WhatsApp group, especially for this workshop, and also working on digitalization. We can organize virtual by next week or on the follow-up on this workshop, and also to come up with a paper from this workshop in order to disseminate it, for example, as we have in Northern Africa, to disseminate it with our network, and come up also if there is a declaration regarding this, because it is the first time we see this kind of workshop here organized in Africa. Thank you so much.
Next, another person was comment. Yes, my senior.
Thank you very much. I think this is a very powerful panel. You know, they have been able to, stimulate a lot of thinking and bring out a lot of processes that we know we need to now use in terms of next steps. And I see this as a very instrumental part of this conference. Like he said, this process is, well, it has seemed to be technical, but indeed it is also technical, because there are a lot of issues that we need to fish out. We need to know a lot of things. There are a lot of agreements, and part of the problem in Africa we face now poor and very illiterate, environments in our countries, is that there are a lot of documentation, but there are very few people to read. And those who read are not necessarily those who need them most. And then those who need them most are the ones who don't even have access to them. So that complicates the issues. So we need to be able to see how this information can actually be brought to the people. And I'm glad that he also mentioned the question of radio. Community radios are powerful instruments that we often forget to use in the face of Facebook and Twitter and those kind of things. But I think it's, if we look at the context, the cultural elements that can be utilized to make our messages go through, but also to organize. One of the things that I am thinking of that needs to be really looked into is organizing and building movements at local level, at national level. Because our governments are also very aggressive and very repressive. And engaging them at a level when you're still building that confidence among yourselves, you need to be a movement. You need to be together and to establish a power base that can be reckoned with. And so that for me, can be a way to get recognized. And like, the panelists have said, it takes a long time to establish the kind of credibility and recognition that is required by, state authorities, but also by even other agencies, international, but also multinational corporations. So the integrity that is required and the consistency that is involved to continuously engage and be known for that purpose is also important. I mean, recently in Sierra Leone, to give an example, well, not recently, I mean, the past few years now, we had been pushing a lot for a reform of the natural resource governance, processes. And so, I mean, it was not easy, it was not rosy, there was a lot of conflicts with government, but then later on, they recognized that there was need to change. And so the review of the laws and the fiscal and regimes now required more, participation. And so we are brought on board. And so right now, the bills are in Parliament, and when the bills are being discussed by the Legislative Committee, we're all there. They invite us. They say, come, we have to discuss. And they'll actually listen. Before this time, it doesn't happen. Nobody goes there. The parliamentarians, once the bill is there, it's no longer open to anybody. Nobody influences it. It's different. But it takes a lot of time. And because over a period we build a movement, a coalition of civil society organizations working on natural resources over 10, 15 years. So that has built the confidence, and also because of lack of non-compromise positions, because people can be influenced and bought over and then compromised. And then they become, people in the hands of authorities. So I think it's a powerful process, but it will require very dedicated and deliberate processes and commitment to make it work. So the question I will have is, bringing us together here is a start, and making us begin to know is one way. After the starting, what is the plan for IHRDA?
Thank you. Yes, kindly remind us your name and the country you're coming from, please. And then I got the lady on the side.
Merci beaucoup. Je réponds au nom de Constant Admis. Je suis de la République centrafricaine. C'est bon? OK. Merci beaucoup à tous les panélistes. Ce que je tiens à souligner, c'est le développement architectural de toute cette thématique, toute cette option et l'intégration de tout afin de voir comment articuler l'AFTA au niveau panafricain. Ma préoccupation est celle-ci. Est-ce qu'on peut avoir une stratégie spécifique d'implémentation au niveau national? Parce que au niveau panafricain, le développement de l'AFTCA est vraiment riche et c'est beaucoup plus complexe. Donc, si nous disposons d'une stratégie ou je peux dire feu de route, non, feu de route, ça ne convient pas, une stratégie d'implémentation au niveau national. Et comment on peut pérenniser maintenant les acquis sur le plan panafricain? J'espère que la traduction a été bien faite parce que c'est un peu...
Thank you
Merci.
so much, Central African Republic. My sister, please.
Thank you so much for the opportunity.
Remind us your name and the country.
Okay, I'm Eve Nyemba. I'm from Zimbabwe. Yeah, and I work with the Zimbabwe Coalition on Data and Development. And my few comments really are just reiterating what was discussed yesterday about the complexity of the issues that we are discussing here and the kind of populace that we are representing here. We are representing the grassroots communities, we are representing women, we are representing children, we are representing youths. And I think that there is need for us to simplify the AfCFTA agreement so that it is palatable to the communities that we are trying to represent. Simplification into vernacular languages, simplification by way of even flyers, pamphlets, going into the communities and simplifying and breaking down the issue so that they can understand, because they are the most affected in terms of trade. We have informal traders, we have unequal trade even at the local level before we even begin to talk about international trade. So it's quite important for the simplification of these documents so that even the government itself, some government officials don't even understand what the CFTA agreement really is about. And I also think that we also need a multi-stakeholder approach. Here we've been speaking to ourselves as CSOs, but I think the next step is perhaps to convene a multi-stakeholder meeting where everyone is on the table, where business is there, where we have government officials, so that also our recommendations, are quite enriching and we have rich discussions, and the duty bearers are there and they can hear for themselves even the recommendations. They can speak to us even the bottlenecks that they are actually facing in terms of implementing this agreement. Thank you.
So much. I heard there's another lead at the extreme end near Gay. I thought her mic was on. No. Okay. It's okay? Okay. Can I have my panelists to respond some of the questions and maybe the comments that have been made by the delegates? Mr. Gay, please.
I'm glad you pronounced my name right. Yeah, I have heard Gaye, all kinds of Gaye, Sowe, all kinds, but that's fine. Yeah. What do we have in IHRDA according to, is it Ibrahim? Ibrahim. There are many Ibrahims in Sierra Leone. Ibrahim. Is it with I or E? Yeah, I think that is what the next panel, the next steps will be discussing. Yeah, but at least the good thing is GIZ is here. I'm sure if we agree on what the next step should be, it would be very easy for us to sell to GIZ in the sense they're very ably represented. Yeah, so that is coming up. Yeah, what do we do? I don't know. I was just thinking, Constance said something about, having plans at the national level. How do we give, meaning to all these commitments? And I was thinking maybe just things that are I wanted to throw out there. At the UN level, the Security Council, I know that is on Women, Peace and Security, 1325. The resolution requires states to come up with national action plans on women, peace and security. Do we push for the AU to come up, I don't know whether we're going to call it a directive, for all our states to come up with action plans on how to mainstream or how to implement the AfCFTA at the national level? I think that could be an option. And Daya said something about the African Commission, receiving reports on what we have done to implement the Maputo Protocol. So which means we're really not just talking about the African Charter, broad enough to include the Maputo Protocol. Do we also make that a requirement, as in when you report, your national report, to have a significant part of it, a significant part to address trade and human rights, as in the AfCFTA processes? How far have you gone into making sure, particularly those bits that really are very human rights focused, how far have you gone into making sure the processes are mainstream, proper consultations, the concerns of vulnerable people are taken care of? How do we do that? I think that is something we can look into. And of course, civil society organizations to submit shadow reports to the African Commission. I mean, if maybe you have an organization working on natural resources, like Ibrahim, our friend here from Sierra Leone, if civil society organizations are discussing a shadow report for Sierra Leone to be submitted to the African Commission, he can make sure that shadow report has or contains significant information on how natural resources are utilized in Sierra Leone. This is why earlier on I was talking about being open-minded, as in we just have to make sure we explore all options, making sure whenever there is a discussion on human rights, we really do not have to forget the issues we've been talking about since yesterday. Make sure these are adequately reflected in our engagements with the Commission, in our engagements with the committee. I mean, unfortunately for a lot of us, we treat international law as foreign law. The African Commission is in a foreign body. The Committee of Experts is in a foreign body. It's an African body set up by us for us. So we really have to, do better, in engaging them. If you don't have the observer status before these bodies, try to make sure you do that. And of course, our lawyers would be very happy to guide you so that when there is need for you to travel anywhere to speak about an issue, you would be in a position to do so. So just, as many options as possible we can use. But again, like I said, we definitely need to find a way of making sure these things have a meaning at the local level. Whether we're going to talk about national action plans, have them included in the state reporting procedure, I'm sure those are conversations we can have, Thank you.
Salima?
I agree with a number of the comments that were made around
Kindly bring the mic
building,
closer.
around the need to have strategies at the national level. And at the national level, even when we are talking about sensitization, I think it's important that we identify, just say we are going to deal with this group of traders, and this is the group that we are going to sensitize, and then the resources will be done. So identifying an institution that can systematically do a nationwide sensitization process, and this will be a government department. I see that from our national context, this process was appropriated by the Ministry of Justice because there was a lot of resources, a lot of travels that were involved. So there were a few people who were seconded to be in the process of negotiating, and so far they are the ones who have been involved with the process. But there is need to identify the relevant line ministries. Either it's trade or, maybe working with associations of traders, something like that, that is more structured. But also in terms of the next steps, I think it's important. George here is an academic. I don't know how much is committed to doing research around this process in a more sustainable manner. But I have seen through advocacy around other processes that partnering with academics is useful. And for many of you in a national context, you will know that governments, usually when they want to be taught about something, they will identify a doctor, a professor, somebody who has researched in this area. They are the ones they want to speak to. Also members of parliament. If there is a committee, they will say which doctor, which professor has researched around this area. So identifying such people ahead of time to interest them to engage with this process and do further research around the area such that they are involved in the advising. Of course, they have to be people who have a human rights angle to things to be able to advise from a human rights-based perspective to advise the governments. Otherwise, sometimes it may be difficult for just other civil society people to influence what the governments are doing at the national level.
George?
Yeah, so thank you very much, Gay. Lima and all colleagues. Your contributions, really, we embrace them, we adopt them, if we could say so. And we're hoping really they'll filter into the final action plan that we are going to present and suggest in the next couple of minutes. Once then we do get into that part. I wanted to make 3 key suggestions, and they're not suggestions in a sense, it's actually a summary of what you've said. And why I think it's important is that I really hope that they find traction or they find a space in the final action plan. The first one is what has been emphasized across the board by everybody, including the first question that was raised earlier by a colleague up there, is that we have to understand, yes, perhaps it might appear technical and complex, but our role as human rights defenders is to break it down and make it granular, make it chewable to the people we are actually engaging in. And that, of course, means first we appreciate what it is, understand what it is, and equally perhaps sensitize people. And I know our colleague from Sierra Leone said, we want to hear what IHRDA wants to do. I throw back the question the other way around, because that's what I'm hoping the next session just focuses on. It's not what IHRDA wants to do. What do you want to do? What do you commit to do? That's a bigger, much more important question, so that the aggregation of what you commit to do is what then becomes part of the action plan, that then there might be need for coordination, which IHRDA is happy and willing to facilitate, including what you suggested, the multi-stakeholder dialogue, which I think is actually a very important proposition, which it becomes an activity out of the overarching strategy. But the overarching strategy is this networking, popularization, sensitization, communication. And why I think is also important is that already in the room, we have people who have actually shown capacity and willingness to expand the tentacles that I have been referring to at Total News, I've been referring to West Africa Radio, and other actors, so that perhaps one of the commitments I'm hoping to hear from everybody is that by the end of the year, I'll have either hosted a social media, Twitter space, Facebook, radio show, SoundCloud, or I'll do something. I'll gonna organize something, having come from Nairobi. For me, that's actually a good commitment. The second point is investing in R&D and capacity. Of course, as an academic, there's no way I'm not going to tell you, you're going to have to invest in research and development. As human rights defenders, talking on the streets, engaging the way we do, without data, without evidence, aggregated, disaggregated, it's not going to take us too far. And I think we have partners like GIZ and even also our member states, including African Philanthropy, that are saying no more will we just be listening to sound bites, juicy stories that is not backed up by data, by evidence. So you're going to have to make sure that in your institutions, if you're working in an institution, you are spending some money, allocating some resources to research and giving those space, time, energy, and effort to actually conduct research so that they understand and appreciate these things, so that they not only become thought leaders, but they're also able to capacity. The final point is tracking implementation. I know I've been trying to talk about this dashboard. I know I've been trying to talk about this scorecard. I really hope it becomes one of the tangible, low-hanging fruits that I know also perhaps IHRDA can be able to motivate. Over.
Thank you so much, Dr. Mkundi and my able panelists for your time. And I want to thank all the delegates for contributing during this session. Sorry, we've gone into the tea break. I think it has been a very insightful and educative session, and we hope that some of the issues that we've been able to talk about, we'll be able to further them and ensure that we actively and effectively engage in the FCTA processes. Thank you so much.
Thank you.
A round of applause for our panelists, please. Thank you. Or Lydia?
When do we
what
done?
next?
Jenny, you came late today again. Yeah.
Now I'm on page 19. The 30%. I write it, then I have to give it to monitoring and evaluation to review, then it goes to the program manager, then that direct, so they all need time. They doesn't look like
Check 1, 2. 1, 2, check 1, 2. 1, 2, check 1, 2. Shit. 1, 2, check 1, 2. Check 1, 2, 1, 2. Check 1, 2, 1, 2. Check 1, 2. but we want to be a bit more specific. So we just want to spend some time, split up into, perhaps we are a small team here. So we could split up into 2 groups, or we do 3. We are 3 is workable. Split up into 3 groups and essentially discuss or reflect on 3 key points. Specifically, what actions are we going to take? Look within your mandate. IHRDA, for example, we say, yes, we principally do litigation, capacity building. We've already even had some ideas talking to partners. Richard said, let's think outside the box. Already, we've noted some action points to take. We will engage our colleagues in the children's rights sector more actively. So we want you also to think, look within your mandate. What do you think specifically we can do? Let's put action points, action words. We will train, we will meet, so we want very specific action points. What will you do within your mandate? As a human rights defender institution, in your thematic focus area, how are you going to mainstream human rights into these AFCFTA processes? And perhaps vice versa. So you're already doing human rights, but how would we introduce discussions or engagements on AFCFTA in the work we do? We anticipate that there might be some challenges. So what challenges do we envisage? And then what solutions would we propose? So just 3 key things that we would discuss among ourselves in these groups. Jenny is excellent at getting people to dance. So I said she should come and help us.
I'm saying, please don't give Gay and Richard ideas. Hi, guys. So as I said, I work with children. So I'm looking for a DJ. John, if you can be able to put for me music, any music. Yeah, Gay. But it's good. No, but guys, you have an 18 experience of being a child. So you have 18 years of experience being a child. So you have probably more experience being a child than you have been an adult or any other thing you have been before. Marriage, or whatever. Or probably there's some who can argue against that, but no. DJ. Any music? Can we all stand up? Can we all stand up? So I want us to push our chairs in.
Push the chairs in.
Yeah, you get out of the chair and push it in. Rizan? In, so you have space behind you. The idea is to have space behind you. You know, okay, put an African music. They don't want to do.